Due to the fact that my last time I was raked over the coals by the Glendale news press and several other issues, people have been naming names, so I'm going to name names as well. In 1996, Officer Holmes was charged with sexual improprieties of 2 Armenian females, and it cost the city at that time approximately $400,000. Officer Perkins worked outside, and the staff and everybody denied this. Staff has also denied the fact of Officer Holmes. Okay, I'm listening for the city staff's comments because, as you commissioners know, I do keep a paper trail, and I'll be more than happy to bring in the paper trail. Matter of fact, I'll leave you some paper trails today. Due to the fact that salaries and compensation do not have to be considered in closed session, I'd like to ask you a question. Sergeant Breckenridge received a death threat in the last quarter of last year. Received a take-home car, and that was approved by then Captain Perkins. My son has a bounty on his head of $25,000 by the cartels. Federal government does not give him a take-home car. Also, I came to find out that after Perkins left, that take-home car was taken away from Breckenridge. If he is really given a threat by someone here in the city, I'd like to know why was he taking away his car? In the last quarter of 2008, there was, and it's now in the process of going to court, 2 other Armenian females, repeat, 2 other Armenian females were sexually harassed, were asked for sexual favors by a Glendale police officer. At this point in time, it's going through the court process, so I'm not going to go into any further discussion on that. But once it gets through the court process, I'm going to ask this commission 2 simple questions. Number 1, will the city of Glendale pay for this officer's improprieties? And the second question, will this officer stay on the Glendale PD like Officer Holmes has after this 2 ladies in 1996 were awarded $400,000? I also want to say one last thing. I've been asked numerous times why I haven't been coming to the city council. My mother is 94 years of age, lives at home, has Alzheimer's disease. I change her diaper, I give her medication, I feed her, and I make sure she gets up, and I keep her mentally engaged. I'm also in the process of connecting the dots and completing my paper trail because I'm not done with this yet. I'm not done with the city, and the city and I will have fun, especially when the other organizations start taking their shots. Thank you very much.
Thank you, sir. Thank you for your time.
Oh, one last thing. These are documents that I'd like the commissioner to have regarding the fact that benefits do not have to be in closed session, and there's also documentation of Perkins having outside work. Thank you.
Are these just public information, Mr. Spiritu? I just want to make sure that we're not giving anything that would affect any employees rights in the future for any hearings, any other issues. So I want to make sure that what you've given us is not in any individual's actual personnel record.
It is in that individual's personnel record. However, he is no longer part of the Glendale Police Department. He is no longer an employee. The other information is regarding the Brown Act in state Supreme Court cases.
Okay.
So that's all public information.
I appreciate it. I just want to make sure that we don't get ourselves in trouble by looking at a document that we shouldn't. Thank you very much.
No,
I appreciate it.
It's not privileged.
Thank you. So much. Okay, no more cards. Next.
Eligible list established.
Store.
Mr. Chair, members of the Commission, the item before you are the eligible lists that have been established since our last meeting. As you can see, there are two lists, one involving an equipment operator, one a promotional recruitment process, the other involving a senior office services specialist in our benefits area. Again, an indication of a bit of a slowdown in our hiring. The report indicates the total number of applications received, and then in the far right column, the total number who made the eligibility list. If you have any questions, I'd be happy to try and answer them.
Total applicants were 138, and one person made the eligibility list?
Yes.
Wow.
We were seeking some experience in health insurance benefits in that area, and
You got a lot of applications on just
a lot of
general.
applications, yes, but not a lot of specific
Okay.
experience.
Any other questions? Okay, thank you very much. So, what's next?
Reapproval of civil service rule amendment.
Door?
Mr. Chair, members of the Commission, at our February 11th meeting last month, the Commission approved a single amendment to the rules having to do with the transfer of probationary employees. This amendment was unanimously approved, and that language that was approved is provided for you in Exhibit A, actually on the second page of the exhibit. Following the approval by the Commission of any amendment, the further action is required by the City Council to ultimately make the amendment, get the amendment approved. This item was brought before the City Council at their regular meeting on March the 10th. The Council did unanimously approve this amendment, but they did make a minor change to this amendment that would limit this type of transfer to only one occurrence. This was brought up on the dais when the item was being discussed, and this staff, myself, the city attorney, felt that the idea that was proposed, or the modification, was actually a good one. In fact, it was something that Commissioner Devine had brought up when it was being addressed here before the Commission. The Council then did approve that amendment with the change, and we felt it would be appropriate then to have that come back before the Commission to either reaffirm or reapprove that amendment with the change that the Council put forth on it. That revised amendment is addressed on Exhibit B, and if you look at the second page, the new part of it is the addition of item D under 3D, which simply says if the employee considered for transfer is on probation, that no more than one transfer be permitted following the initial appointment. Essentially, what that would do is limit this type of a lower qualifications transfer to just one instance, to where a person doesn't get 2, 3, 4 chances at a job. And I think that was the original intent of this amendment when we first came up with it. So, again, in an abundance of caution, we felt it appropriate to bring this back before you to reaffirm what ultimately was approved by the Council. So, with that, staff is recommending once again your approval of the language contained in Exhibit B of this item.
Any comments? I appreciate that this came back to us. I think that's the proper procedure for us to actually approve this. I know that some felt that it might not be necessary, but I think that just not the actual content of what was passed, but just the process in which it has to come back to us because it's our rules for a final approval is necessary. With that, maybe have roll call, please. Oh,
Move to whatever.
move to approve.
Move to approve.
Second.
Move to whatever?
Move to whatever.
I approve that whatever.
Move to approve, and there's a second. Can we have roll call, please?
Commissioner Devine?
Yes.
Commissioner Manukian?
Yes.
Commissioner Gantis?
Yes.
Chair Karian?
Yes. What's next?
Report on authority of commission in approving advertising budget.
For Petra?
Mr. Chair, members of the Commission, there was a request by the Commission to provide a legal opinion regarding the Commission's authority as it relates to the advertising budget of the Commission. The Glendale City Charter provides that the power to adopt the budget vests solely with the City Council. The Charter does, however, provide that the Civil Service Rule shall provide for public advertisement of all competitive examinations. That rule is captured in Rule 4, which allows the Commission to review the announcements. It does not, however, grant the Commission the authority to expend funds to disseminate the announcement. The authority currently falls within the function of the Director of Human Resources. But as you know, the Director of Human Resources periodically, I think quarterly, brings back information regarding announcement distribution and encourages comment from the Commission. If you do seek to have authority over the budget, then that's something that you would have to adopt by way of a rule change.
Okay. Any comments?
I have two questions.
Sure.
First question.
You can have three if you
Oh,
like.
wow.
No,
Feeling
only
good
two.
today. Oh, Gandis says only two.
Two.
Okay. First one, I don't recall what the purpose of our asking for this opinion was. What were we trying to look for or accomplish by having this?
You're asking me or you're asking?
I'm asking the Commission, or whoever might remember.
I remember.
Mr. Gandis?
I need to be called on before I can ask, though.
This came up in the context of how monies are expended that I recall in budgeted in terms of, are we spending more in newspaper advertising? Should we not have authority, or are we spending enough? We talked about the police budget is not something that we get to look at. They have their own. The fire has their own. Came up in that context that I recall, and then and suggestions that we had made in the past that maybe the City Council should up the advertising budget so we could have the opportunity to spread the word of these jobs to more and more people. That was the context that this was brought up in.
And my second question, do I still get that, even though he spoke?
I said you could have two.
The second question is to Ms. Arpetian. On your last paragraph where you say Rule 4 allows the Commission to review the announcement, it does not grant the Commission the authority to expend funds to disseminate the announcement. My question is, how about having the authority to reallocate or recommend reallocation or adjustment of how the funds are spent? For example, as Mr. Gandis pointed out in his answer, maybe we feel that they're spending too much here and not enough here in this particular media. Can we suggest or recommend or ask the Human Resources Director to reallocate or change the amount spent?
Absolutely. I think that would come to you by way of a recommendation to the Director when this item does come up. So, and I think correct me if I'm wrong, I think you even solicit that type of request, but you probably could speak better for yourself.
Mr. Chair, members of the Commission, I do have a reporting relationship to this Commission. So as such, any types of suggestions or direction relative to advertisement or anything, you can generally count on me following through with that. So I'd say as a matter of general practice, this is what occurs. Now, if you were to direct me to spend $1 million on advertising and that $1 million isn't allocated by the Council, there's not a whole lot I can do. But the money that is put aside, certainly I would take that direction, as I think I have.
We're half the boss.
Just so we're clear, I wanted to really know, we review the actual budget on advertising and make comments on it and make like suggestions and all, and I wanted to know if we have the authority at all to really do anything. Technically speaking, if Mr. Doyle wasn't here and another human resources person was here, which basically had decided, I really don't care what the Civil Service Commission is saying, it's my authority, he is within his rights not to hear any recommendations from us, correct?
What I would recommend that you do in that instance is to specifically seek the budget from the City Council so that you would have the full authority to then spend it.
Well, if it's not in the charter, then we won't have the authority. I just wanted to know, okay.
Don't forget, we could also fire half of his body as well.
Half of Mr. Doyle's
So,
body,
I
you
mean,
mean?
whoever the director is,
I got it.
he serves, half of him serves at our pleasure.
Half of Mr. Doyle serves for us. I got it. Well, Mr. Doyle, make sure that half always comes to the meetings.
We get the better half.
Mr. Mnuchin?
I just want to make sure I understand correctly. So at least, if I understand correctly, what our role here is, what we can do is make recommendations for reallocations of the existing, whatever we're budgeted for. For example, if Mr. Doyle wants to do all of his advertising at a topless bar billboard, and that's not acceptable, and we recommend he should use the newspaper, that is something we can, but we cannot allocate more than what was being granted to us. Okay. All right.
That's good analysis, Sam.
Not that that would ever happen.
Had to do that just because
Guarantee
I know
you
we're on TV.
I've seen him. I've seen
I
him.
know
You
you're
can
gonna
sue me
get-
because it's actually on tape, but a
was
punch to the arm is necessary.
I was going to say, you're going to be getting calls tomorrow, Mr. Mnuchin.
Hey.
All right.
Mr. Chair, and beyond that, beyond what's been approved, I do recall in years past getting direction from this commission that Mr. Doyle, you should try and get more money in the budget. You should try and get more money for certain media, commercials, things like that, which I have made those requests, and depending on the budget year, achieved some success with that. And so the budget has gone up a bit, and I'm thinking in the next few years it's going to shrink a bit. But the one good thing about advertising is probably the most effective means in this day and age is online, internet, and it's very, very reasonable. In many cases, it's free. So there's good opportunities, even in lean times, to get our message out. So
Isn't Rosie the queen of free? She finds all these free sites, if I recall
she's amazing,
correctly.
yes.
Well, thank you so much. And as I said, this was not directed to anyone. I just wanted to make sure. And then, Ms. Arpita, if you don't mind in the future, if you can actually, if you're referring to a particular section in that code, maybe just give us a copy of that also so we can actually have everything in one package when we're reviewing it.
Will do.
That would be very, very appreciated. Okay. Any other questions? Okay, what's next?
Report on medical and rehab transfers.
Mr. Doyle.
It's me. Mr. Chair, members of the Commission, this is a follow-up item from an issue that came up at our last meeting. At our last meeting on March the 11th, we had a rehabilitation transfer that was brought to the Commission in closed session. Under Rule 3 of the Civil Service Rules, the Commission is to receive notification of such a transfer when an employee is placed in a rehab transfer this manner. When I brought this to you, there were some questions, much to the extent of why do we even need to see this if we're just being notified, and so I was asked to bring this item back. In this report that I prepared, which isn't a very long report, but essentially I also included some information about medical transfers, which are also addressed in Rule 3 of the Civil Service Rules. They're a similar type of circumstance as the rehab transfers. Basically what it involves is city staff fulfilling its obligations under the law to not only address employees who either have disabilities or significant work restrictions and engage in an interactive process and ultimately seek some sort of accommodation for them. The difference between a rehab transfer and a medical transfer is that the rehab transfer generally involves a employee injured on the job versus a medical transfer. The other difference is that under the rules, the medical transfer requires Commission's approval, whereas the rehab transfer only requires Commission notification. Why was it done that way? I have no idea, but it's probably a good discussion to have at this point because, on the one hand, I think the reason these items were placed within the rules was probably to protect the merit system and to ensure that staff or department wasn't somehow circumventing the merit system by placing people in jobs that they may or may not be qualified for, whatever the case may be. So it was really originally designed, I'm sure, as a protective measure. On the other hand, as I point out in the report, staff has obligations under both federal and state law, under the federal ADA and the state Fair Employment and Housing Act law, to engage in an interactive process and to seek accommodations when we're placed with an employee or even an applicant who has some type of work restriction or disability. And we have these obligations regardless of what the Commission wants to approve or not to try and place someone in a job. So again, it's these two types of transfers are important. They're an important tool as far as us complying with the law. As far as whether you want to keep these items within Rule 3 of the Civil Service Rules, I'll leave that up to the Commission. But I do want you to be aware that we do have significant obligations under these. Under the, again, various federal and state laws to do these accommodations. So with that, I'd be happy to answer any questions.
Go ahead.
Well, based on Mr. Doyle's explanation and what he's written, I think that we really have no authority to go one way or the other if it falls under the medical or disability type transfer. So my feeling is that we should change the rule and take the Commission out of the loop.
Anyone else? Any comments before I make mine?
Okay. Quick question. I just want to, one more time. The only difference between the due to injuries that took place at work, correct?
Correct.
Okay. And that one, we just get notified and we have no authority over?
That's as it's currently
correct.
Addressed in the rules, yes.
And how often does this happen, just for curiosity?
I would say 2 to 3 times per year. And a lot of these, a lot of times when we're faced with a disabled employee or an employee with work restrictions, we're able to accommodate them in their current job classification. So in many cases, we don't even have to deal with this process. But when there's a situation where that person, maybe they've sustained a back injury, or maybe they have a disease or an illness which restricts their ability to perform certain functions of their job, and yet they can very easily do another job in a different job title. That's when we would consider this option in placing them in another assignment. But I would say probably this occurs 2 to 3 times a year. We are, in fact, probably 30 times a year, we are having these types of meetings where we are faced with a disabled employee and seeking to accommodate them. And when we can accommodate them, we do it, which is probably the majority of the time within their current job class. Those times that we can't, we either have the decision of placing them in another job, which would bring this into play, or in some cases we just simply can't accommodate, or we can't make a reasonable accommodation and that would require us to separate that employee.
Okay, thank you.
Ms. Gant?
Is that correct that if the employee's injured off the job, motorcycle accident while he's going to whatever that place is? friend's house or something, they have to be treated exactly the same way as if they're injured on the job?
Under the law, yes.
Then I tend to agree with Mr.
There's
Divine.
Obviously, there's a great deal more sympathy when it's someone shot in the line of duty or electrical worker who falls off a pole or something like that, as opposed to somebody who is injured or maimed skydiving or something like that.
Yeah.
But when we're faced with employee disabilities or work restrictions, we really have the same obligations, one way or the other.
It seems to me that we really. Is this rule a relatively old rule, the difference between the rehabilitation and medical transfer that might predate the
Oh, absolutely, yeah.
Yeah, I think, Mr. Devine, I think the rules have changed, and I think that leaving it to our discretion, not that we wouldn't do it, but who knows who's here, I think this is really something that needs to be handled through with the city manager and the city attorney, the legal type stuff, and I don't think we should leave it there. So my recommendation would be that it all be under the same umbrella, that we get notified, obviously, but that it not require our approval.
Can I ask, I'm sorry.
Go ahead, go ahead.
Can I ask, I just want to make sure I understand this clearly. I think what we're talking about here is not. It's just the difference between if you should report it to us or not. I mean, we're not talking about making any, taking any part in that decision, correct?
We have a part in one of them.
One of them, yes, I understand, but we're talking about also the other one.
That's correct. I mean, I've addressed this issue broad enough to where whatever the commission's desire is, you can give me the direction. But
Just want to make sure I understood correctly.
So let me just understand one thing. If the, you know me, I need to look at all the angles. First of all, I asked for this to come because I keep looking at these things, and even, in my opinion, even notification is a waste. We have no authority on it. There's nothing that a notification will do for us to take an action on. There's no reason for us not to approve it when a doctor and a city manager has already approved it. To be even notified, in my opinion, is not a waste of time, but it's just something, an extra step that we should eliminate, in my opinion, completely, both of them.
I agree.
And it just makes no sense whatsoever. I just want to know that if an employee is intentionally, because the manager is in cahoots with the doctor and they demote him or say that he has to do a lesser job, does he get paid the same amount of money?
What? You lost me.
The lower, when you are transferred, correct, to a different job because of your physical inability to do that job. Is your pay still stay at the rate that you had the prior job rate pay?
excellent question. When we're dealing with a job-related injury and that accommodation is made, typically they're done with Y-rated.
Y-rated, okay.
And that means they stay, their current salary is frozen, and they more or less wait until the salary of the lower pay catches up with the current pay.
What was that called?
Y-rated.
Y rating.
Yes.
Why
So
like you?
So if I'm earning $4,000 a month and I sustain an on-the-job injury and have to be placed in a lower position, which pays $3,600 a month, I would be frozen at $4,000 a month. Even if there's cost of living increases and taking effect, I would stay at that level until the $3,600 a month part of it catches up.
That's only for rehabilitation transfers,
Correct.
not for medical transfers.
Correct.
That's not part of the rules, that's just what we do.
That's just what we do. Yeah.
And is there any appeal, if somebody wants to appeal their transfer, is there any appeal to the Civil Service Commission from those rules?
Appeal a transfer.
Does the employee have to agree to the transfer, first of all?
Yes. I mean, yeah, you've seen transfer forms come through here. The employee has to sign it and say, yes, I want to.
How about if they say, no, I don't want to accept the transfer?
If they don't want to accept a transfer, then we either have to find another possible outlet or place to put them, or if they don't accept any of our proposed accommodations, then we have the ability to separate them from employment.
Even if they're not on probation.
That's correct.
They'd be subject, though, to civil service steps. In other words, they'd have to go through that, Skelly, and the whole 9 yards if they're off probation.
It gets a little more complicated, but
That's why I was asking.
it's essentially when on a disability case or a medical case, before the employer can separate someone, they have to first offer them various accommodations, and there's another option through CalPERS of a disability retirement, which has to be considered as well before someone is separated. But it depends whether or not we have a viable alternative for them. If we offer them a viable other job somewhere else, then they would probably not be eligible for a PERS disability retirement. But if there's no other alternative, and we have to separate someone because of a disability or some type of work restriction, then we would have to offer that to them as an alternative. And that's someone of any age, whether they're 45, 55, or retirement age or not.
Just to follow with what Commissioner Gantis said, however, if they're separated as a result of that, they would have the same rights under civil service rules as another employee who was separated from the job.
Not if they're granted disability retirement.
I got it.
That's a separate track. But but yeah, if someone was offered 3 different accommodations and we said, look, we've tried, and that's what this whole process requires under both FEHA and the ADA, requires us to explore all these alternatives and not just propose things, but we actually have to sit down with that employee and meet with them and say, hey, how about this? How about that? If they turn us down on everything, then we would have to go through the Skelly process and separate them in that manner.
That's in other words, following up with Mr. Epkarian, Chairman Epkarian.
Yes.
In other words, if they're part of this is the disability, if they get the disability, then technically they're not separated for civil service purposes. Correct. But if they don't, and they choose to do nothing, and you say, sorry guys, you're just going to have to leave, that then kicks in all the Skelly process and everything.
Yes.
Okay. Well, my recommendation would be that we would actually strike out the last sentence in rehabilitation transfer that says the city manager shall notify the commission of the said action, and then cross out the last sentence in medical transfer where it says the employee shall be given notice of the proposed transfer before the appointing authority files the request with the commission.
Well, I don't think that is what you want to do, because you have to rewrite the medical transfer.
Yeah, I would like to. My suggestion would be to do that. If anyone has a motion with that,
I'll move that both the rules be changed to medical and disability to exclude the commission involvement in the process.
Second.
Okay, there's a motion and a second by Mr. Mnuchin.
That's to copy everything.
Could we have roll call, please?
Commissioner Devine?
Yes.
Commissioner Mnuchin?
Yes.
Commissioner Gantis?
Yes.
Chair Epkarian?
Yes. So this will be added to the additional,
Yes.
to those amendments.
To
and
the
if you can
list of
just bring it
amendments,
back.
this will be added to that.
When is that coming back?
May 27th.
Okay, great, thank you so much. What's next?
Agenda forecast.
Mr. Chair, members of the Commission, the agenda forecast is before you. We have no reports at this point on the April 8th meeting. The April 22nd meeting, a number of reports that had been directed to come back from before, involving the Commission's motion to request to hire outside counsel, the jurisdictional commission over investigations, as well as our quarterly advertising budget report. That's all set for April 22nd. And then the next significant meeting where there are items planned is consideration of the rule amendments, as has already been stated, for the May 27th meeting.
Mr. Chairman,
Chair.
I was just going to recommend that maybe one of the items, they're both time-consuming on the 22nd of April, get moved to May 13th so that we're balancing our work schedule.
Okay, before we do that, I want to make a suggestion and see if anyone agrees with me, and if you don't, then we'll move it. Mr. Devine?
Yes, I was going to suggest that for the June 24th meeting, when Commissioner Gantis will not be here, that we reschedule that hearing on.
That I agree for sure. If you can just move that to the July 8th meeting. Okay. Just a quick note, as a Chairperson, I can move things around on the agenda, but I wanted to get your input, and this is just on the agenda item, not to discuss anything else. But my recommendation would be that we only we do not consider any longer the Commission's motion for request to hire outside counsel, and then listen to jurisdiction of the Commission over investigation and recourse available, and then if necessary, we can put that item back in again at some future point.
I agree.
I agree.
Agree.
Unanimous. So
You're easy, Albert.
there, I like it when everyone agrees. So the only thing we would need to do is just listen, just have the jurisdiction of the Commission over Investigations, and if necessary at that point, then we will do what the Commission desires to do at that point. So, Petian, you're okay with that? Not to do to the both of them? I'm sure it makes you very sad, but
That's part of her honeymoon period.
Yeah,
Doesn't mean it won't come back on.
it doesn't matter. It doesn't mean it doesn't
That's
come
a
back.
yes.
Okay.
I may actually not be here on the 22nd, so somebody else in my office may need to take that, but that's not confirmed yet.
That's fine.
Well, if that's the case, because this issue of the investigations and recourse available, it's a very important issue. Unless you feel that person is adequately schooled in that. I know you've spent time becoming updated on this. I would just assume not have it heard unless she were here, unless it's somebody that she feels adequately schooled on it.
I feel comfortable that Mr. Howard would do a good
Yeah, I
job.
was just
Howard
going to say, if Scott Howard,
Well, she didn't say Mr. Howard.
actually, I was going to say, if it's Scott Howard, we actually do want to move it and then bring you back at some point in the future. But what can we do if it's Mr. Howard?
Oh, we're stuck with Mr. Howard.
What can
the
we
heck?
do? We'll just
Way
stick
too
with
many
him.
attorneys on this board. Way.
Okay. Any other recommendations or suggestions? Okay. None. What's next?
Reports and information.
Any reports? None. Anyone else? No. What's next?
Civil Service Commission and her staff comments.
Any comments? I do have a comment, just as a continual update on Commissioner Coleman. He had a surgery. He's doing extremely well. Last I spoke with him, which was a few days ago, and he's recovering well, and I hope he's listening, and we wish him back soon.
We need you back. We've got a referee between all of us.
That's right. Okay. What's next?
Closed session, public employee appointment, power plant auxiliary operator.
We'll be going into closed session. That we will not be reporting.
Yes, we will be reporting it.
No, we will not. We will be reporting out, but that portion of that portion of the Civil Service Commission will not be televised. So the televised portion of the Civil Service Commission is done, is finished. Thank you.